Good morning, my dear students. I trust you are all fine. And everything is going on well. Thank God for the gift of life. Thank God for bringing us to a new week. To God alone be all the glory. So I wanted to have this short connect with us because our time is almost gone. And when I meet with you on Wednesday and hopefully on Thursday, I want to tidy up on a liquidation of companies. So I felt I should use today to say a few things on receivership. We would have met on Friday, but for the unfortunate passing away of our colleague and our senior colleague, our lecturer, our deputy governor, please continue to uphold the family in prayers. And just we're all at a loss, short of words. It is well. Yeah, so I'll be sharing my slide with us. It will be a short connect. I just want to say a few things and that you should know about receivership. If you recall, I had talked to you about the powers of a debenture holder, one of which is to be able to proceed directly against assets. I emphasized that an unsecured creditor doesn't have that right. He has to go to court. He has to sue for his money, get judgment, because it's essentially unsecured, unprotected, and all that. But for the receiver, it has been inherent that he should be able to appoint somebody, an insolvency practitioner, to proceed against the assets of the indebted company, to realize those assets, liquidate them, and then hand over the company, of course, back to the director. So essentially, if a company is in receivership, it is not in the process of being liquidated. As you will see, even though the power of the directors may be suspended, particularly if it is in a receivership, administrative receivership, which you can also call receiver manager. If a receiver manager is appointed by a floating charge holder, the directors essentially practically will cease to operate as far as those assets are concerned, of course. But for the fixed charge holder, the directors continue to operate. The receiver only goes after the assets. I hope I'm not jumping ahead of myself. So chapter 19 of CAMA, sections 550 to 563 deal with receivership. It's a highly individualistic procedure. It's a highly individualistic procedure. This is an insolvency procedure, again, similar to liquidation. It's more similar to liquidation and administration, and then less similar to the CVA, because here a receiver is appointed, an insolvency practitioner, to proceed against the assets of the company. So when you combine the CVA, liquidation, administration, and receivership, they are what you call collective approaches to corporate insolvency. So the risk of default remains, and to cater for it, a creditor may require third-party guarantors. Okay, I'm collecting money from you. You are collecting money from me. I'm not sure you will pay. Can you guarantee? Give me a third-party guarantor. Or it could rely on what you call an asset-based transaction. I'm giving you my car. You have to pay me 5 million, but I'm not sure you pay. So please, I'm going to retain title, even though I'm transferring assets to you. I may retain title so that in case you are telling me stories, I can seize and then sell those assets. Again, to secure myself, I can rely on the hire purchase arrangement. Again, title is retained with me. You only have an option to purchase. So these are all security measures. I could charge high interest rates to compensate for default risk. So if I'm advancing money to Angel, and I know Angel is very trustworthy, she can pay. I could say the interest Angel will pay is just 10%. If I'm advancing that same money to another person that I don't trust, let's say his name is Jackson, I could charge Jackson 20%, excessive, very high interest rate to compensate for the risk I'm going to bear, and then I could require the company to provide security for the funds I'm advancing to it. In this regard, it could be either a mortgage or a charge. So I could ask the company to mortgage or to charge its assets to me. And then in the event that the company fails, in either case, I could proceed to appoint a third party as a receiver. So again, just to emphasize that the receivers are generally not appointable by unsecured creditors. They don't have a right over the company's assets. They may sue for funds owed to them. They may move the court to liquidate the company, and then all that. But they do not. Again, I pointed it out. I will still talk about it in liquidation. They don't have a right of priority. So if you are an unsecured creditor and the company, you became indebted to or the company became indebted to you in 1984 and to me in 1999, we still stand on the same platform. There's no priority with respect to time and all that. So those are things I think you already know. A receiver is a person typically appointed by a secured creditor to receive assets or to manage the affairs of an indebted company. So who is a secured creditor? Is a creditor who has been granted a security interest in any property, assets for the purpose of securing the performance of a debt or to guarantee the performance of an obligation. So receivership law is rooted in the law of secure credit transactions under property and company law. And the appointment of a receiver is one of the powers that a secure creditor, mortgagee or debenture holder, of course, when I say debenture holder, we're talking about secured debenture holder, may exercise under a credit facility or instrument. So these are some things. I'm going to send you my slide. Usually, when may he be appointed? We talked about it in first semester when we looked at debentures. Just a second. Okay, so when may this individual be appointed? It can be appointed by a floating charge holder, pursuant to an agreement. So it's not an automatic right. I emphasize that when we met, I think on Wednesday, the instrument creating the charge must have conferred that authorization. But for the fixed charge holder, whether or not there is such provision, he has the automatic right to appoint a receiver. So this is how you appoint receivers, by a floating charge holder or a fixed charge holder or a mortgagor. Or a mortgagor can also go ahead and do that, or by the court. The court can appoint a receiver on the application of creditors, once the charge becomes enforceable. So if I secure my property with a floating charge, and the instrument creating the charge did not give me the authority or the power to appoint a receiver, the moment the charge becomes enforceable, then I can approach the court to appoint a receiver for me. Again, in instances of emergency where there's serious risk of the dissipation, risk that the assets of the company will be wasted or dissipated or mismanaged, then even when the charge has not become enforceable, the court may still appoint a receiver, acting on the application of a floating charge holder. The truth is that the fixed charge holder does not even need to approach the court, except it's not able to. Sometimes there could be a lot of challenges in practice. Otherwise, the fixed charge holder just goes and then takes the asset, at least in theory. So on the application of the floating charge holder, the court, the Federal Court, can appoint a receiver if the assets are in jeopardy, or if events have occurred or are about to occur, which will render it unreasonable in the interest of the debenture holder that the company should retain power to dispose of its assets. So once we see that for example, the directors are now mismanaging this company, then it's not reasonable that the company should continue to exercise that unrivaled and absolute right to use and then to sell these assets in the course of its business. That right has been curtailed or it has been forfeited by that misbehavior. So we approach the court and say, my lord, even though this charge is not yet enforceable, please, please, please help us. Give us a receiver. You know, a receiver cannot be appointed to enforce a debenture that is not secured, of course, by any charge. An unsecured creditor cannot. And then priority rules apply on winding up, Section 207, Section 657. So who may not be a receiver, please look at it, Section 550, look at it. And just note that even a corporate entity, a body corporate cannot act as a receiver. However, you will see in practice that certain institutions, government institutions like AMCON, I think NDIC, CBN, and then these agencies often act as receivers. So if you look at Section 48 of the AMCON Act, for example, so even though a body corporate, generally a company cannot be a receiver, a special statute can confer that authority. You know, so they are court-appointed receivers, and then there are receivers who are appointed by creditors. You know, so the court-appointed officer, just know that he's deemed to be an officer of the court. He's not an officer of the company, and is to act in accordance with the directions of the court. Again, similar to administration. You know, so you have time, you want to look at Fasakin versus Fasakin and all that. The receiver appointed out of the court, again, similar to administration, owes fiduciary duties to the company. He shall act at all times. So see sections 553, 554. Compare it again with sections 305, yeah. You know, shall act at all times in what he believes to be in the best interest of the company as a whole, to preserve its assets and all that, may have regard for employees, interests, members, and all that. So just note that, more or less a repetition. But what is the status of a receiver? Again, if it's appointed by the court, it's an officer of the court, an agent, basically an officer of the court. If it's appointed by a creditor, it's an agent of the appointer, although he has fiduciary obligations owed to the company. So you want to look at section 552 to 554. There's another phrase you come across from time to time is the official receiver. Who is this individual? You come across it particularly when we come to liquidation of companies. So if a company is being wound up, for example, and the creditor of the company moves quickly to ask the court, my lord, please appoint a receiver over a specific group of assets. The court may, instead of listening to that person, go ahead to appoint an official receiver. This person usually is a sheriff of the court or any of his deputies, and is an officer charged with the control of the affairs of a bankrupt company. So once an official receiver is appointed, he takes the place of a receiver, and then he goes ahead to, you know, do what normally a receiver will do. So there are some slight differences between a creditor-appointed receiver and an official receiver. Remember, an official receiver is not the same thing as a receiver who is appointed while the company is still a going concern. If the company is still a going concern, a floating charge holder or any creditor can and say, my lord, please appoint a receiver or a receiver manager. That can happen. But the moment the company is being wound up, it's in the process of liquidation, and the creditor is asking, my lord, please appoint a receiver, then the court may, instead of appointing one, appoint an official receiver. So both of them are officials of the court. But this one, as long as it is in a winding up process, is called an official receiver. So it's appointed by the court as a public officer. He will act for all the creditors. You know, so it's not acting for a narrow group. It's not acting for his appointed, a narrow group of creditors. He will act for all the creditors and for the state. He will control all the assets of the company, except those that are already charged, except those that are subjected to a fixed charge. and so he takes the company through a public insolvency process. He has powers to investigate, he has powers to investigate the affairs of the company. And usually, before a liquidator is fully appointed, this person will also double as what you call a provisional liquidator. Again, we're going to talk about it when we come to liquidation. I just felt I should give you some heads up. So the creditor appointed receiver, you already know, is a private remedy. He doesn't have powers to investigate. The official receiver cannot just investigate, but can move the court to disqualify a corrupt director. That should be these sections around 288, I think so, disqualification of directors, either 280, 281, 281 of those sections, so he has that power. Again, if in the course of carrying out his duties, he discovers that there has been what we call a fraudulent trading, somebody has just woken up. He discovers that there is fraudulent trading, then that same individual can he can also move the court. He can move for the conviction of such persons. So he is also an investigator, essentially. I just felt you should be aware of that fact as well. So there are a lot of other things you need to know. Notification obligations. The company appointing the receiver should notify the court, notify CAC within a particular number of days, usually 14 days. If you fail to do that, there are some sanctions. And then what does a receiver do? Basically, is to go after that property. But if it's a receiver manager is the one appointed by the floating charge holder. The fixed charge holder appoints a receiver who goes after a specific asset. Floating charge holder appoints a receiver manager or an administrative receiver who now manages the company, displaces the directors, and then ensures that he realizes those assets. When he has done that, in theory, he will give the company back to the directors. The directors are not sacked upon the appointment of a receiver. Instead, they are more or less in suspension, but they can still act, as you are going to see presently. So he has a lot of powers, very similar to those of the administrator, particularly if he's a receiver manager. He can do virtually everything directors can do. So you want to see section 556, you want to see the 11th schedule to the act, for his powers. Basically everything directors can do, he can do. So what is the effect of his appointment? We talked about the effect of the appointment of an administrator. I may ask you in the exam to compare the effect of the appointment of an administrator with the effect of the appointment of a receiver. So basically, when a receiver is appointed, the powers of the directors and the powers of liquidators in the members voluntary winding up to deal with the property or undertaking over which his receiver shall cease and remain suspended until he is discharged. So if asset A, B, C, D, asset A, B, C, D are now brought under his control, it means that all directors and liquidators in a members voluntary winding up, they must hands off those assets. They must hands off those assets. But if it's in a creditor's voluntary winding up, where the property concerned is already in the custody of another officer of the court, the liquidator or officer is not obliged to relinquish control of that property to the receiver or manager except by an order of court. So if it's in a creditor's voluntary winding up, then here we are simply saying that a liquidator has been appointed, or an officer of the court has been appointed, because the members have not been able to declare what we call make a declaration of solvency. In such instances, they will only hands off from assets with the leave of the court. But for a members voluntary winding up, where a solvency declaration has been made, or in a normal liquidation process, or in the normal course of directing the company, once a receiver is appointed, as far as those assets are concerned, directors and liquidators must hands off. So again, you want to see UBA trustees versus Niger Group. What is the effect of his appointment on directors? Do they lose their job? No. Their powers are only suspended. So those assets that are not subjected to the powers of the liquidator, of the receiver, will still be overseen by the directors of the company. The directors can even sue the validity of the appointment of a receiver. So if they say this man you appointed is not even qualified, that means they have not lost their job. They are only suspended. So see that case. So just look at this. Is he liable for contract? Is personally liable on contracts he enters unless the contract states otherwise. Primary reason is not the agent of the company. Remember, it's the agent of the person who appoints him. So as he begins to transact with third parties, he cannot carry all those contracts and put the wahala on the company. He should be a third party take him as they see him, unless the contract states otherwise. He bears liability. So this is designed to promote honesty, caution, and reliability in dealings with outsiders and all that. So please look up these sections. For contracts made properly in carrying out his functions, he may reimburse himself from the company's assets over which he was appointed. So I'm appointed to oversee an oil block, and in the course of managing the oil block, I've made contracts, entered into contracts, and I've spent money from my pocket. Then I can be reimbursed. I can be reimbursed from those assets. If he was appointed out of court, he can seek indemnity from the court, from the appointer, but only if he cannot recover fully from the company's property. So these are some things I just felt you should know. Look up these cases and all that. The court fixes his remuneration if none is fixed. And if it's excessive, you can charge it. What does he do? Basically, what he does, like I said, is to verify the validity of the debenture before he starts to appoint, to act as receiver. The instrument appointing you, is it valid? You have to confirm. Notify CAC, notify the company will notify CAC as well. Then you start to work. They have an obligation to give you all the necessary documents, statement of accounts and all that, similar again to receivership. And if they fail to do that, then they will likely be in contempt of the court, so, and all that. Just, of course, he has to render account to the persons entitled to them, make statement of affairs, do his work, keep details. Every kobo he's spending, it's not his money. He has to keep details and all that. So he has duties as to returns, make regular returns to CAC and all that. So what are his duties? His duties are similar to those of directors. I've already said he owes fiduciary duties. He also has to act with skill and then care, so. He can also sue, look at intercontractors versus USC, and institute legal actions and all that. So I'll end with this, just 2 minutes more so that I'll release you. Like I said, it's just an overview. And does receivership, or has the process abolished, has the administration abolished receivership? Not necessarily. Both of them can coexist. But what you should know is that as far as floating charge receivership, or what we call administrative receivership, is concerned, the administration procedure has all but swallowed it. In theory, it can exist, but in practice, I don't see the possibility of administrative receivership still existing. But a fixed charge receivership can exist, can continue, because you have given your car to me to secure my funds. If you default, I only go after those cars, and so usually an administrator does not even have a right over the assets subjected to a fixed charge or to a mortgage, except with leave of court, which we discussed last week. So let me just go through these 3 slides and I release you. Administration and receivership existed side by side in the UK. So when administration was brought into the UK in 1986 by the Insolvency Act, it was envisaged that both of them could exist. But it became act, particularly Section 72A, The amendment removed the floating charge holder's right to appoint a receiver over a company that was undergoing administration. So essentially, once a company is undergoing administration, Oga, the bench holder, hold your peace. You can't appoint an administrator, a receiver manager over that company. Of course, that provision is a going forward provision. It did not apply retrospectively. This meant that floating charge holders whose interests were created before the 15th of September 2003 and still retain the right to appoint administrative receivers. But going forward, from that time, and they couldn't do that anymore. So in Nigeria, do they coexist? Yes, at least in theory. You want to look at sections 450, 452, 463, 476. So, for example, a floating charge holder, not Shari, charge holder, chargee, cannot appoint an administrator over a company that is in receivership before KAMA became effective. You cannot appoint an administrator over a company that was already in receivership. So KAMA came in first 2020, I think that was around August, July. If the company was already in receivership, then you have to allow receivership to continue. You couldn't appoint an administrator over a company that was already in receivership before the law was enacted. So that meant that KAMA recognized that both of them could exist. Administration did not abolish receivership. Similarly, the company and its directors cannot appoint an administrator over a company that was in receivership before KAMA 2020. So you want to see section 462. What this means is that charge holders may continue to appoint receivers over companies. Receiverships that arise from a floating charge have been retained by KAMA, and in some cases, such receiverships may even be a ground for preventing a company from entering into administration. And until the court grants an administration order, a floating charge holder is not prohibited from appointing a receiver. Very important. It is when the court has granted an administration order, say from now, Johnson Ekweme is the administrator of this company, that it is only when that has happened that floating charge holders must be said, go and rest. Thus, a receiver will not be stopped or stopped from functioning merely because an application has been made to the court for the appointment of an administrator. So, this right of debenture holders to appoint receivers is even stronger if the debenture was secured by a floating charge. As such, the court will generally decline to appoint or grant an administration order over a company that is in receivership under a floating charge, unless so please let's continue. As such, the court will generally decline to grant an administration order over a company that is in receivership under a fixed charge, unless you obtain the consent of the charge holder. So the appointer must consent to the making of the order. So if you are approaching the court to say, my lord, please appoint an administrator over this company, and that company is already under a fixed charge receivership, then the court will generally have to ensure you get the consent of that fixed charge holder before you can go ahead. Before the court can go ahead and then make the appointment, So just know that. See also section 476 up to, fixed charge holders may appoint the receiver before or after the making of an administration application. So whether you have applied to the court or not, that's not my business. I can go ahead and appoint my receiver. Similarly, again, the company is being liquidated. Does not stop a fixed charge holder from appointing a receiver because it goes after that specific asset. Essentially and practically, that asset is out of bounds. But I note here in the last slide, but administration may have whittled down receiverships significantly as far as floating charges are concerned. Why? This is because to all intents and purposes, the appointment of a receiver manager by a floating charge is now deemed to be equivalent to the appointment of an administrator. So look at section 452. And a receiver that is appointed under a floating charge would have to vacate office the moment the administration order comes into effect, section 478 sub 1. So the moment the order comes into effect, Oga, step down. Both of them can exist, but it hasn't been abolished by KAMA. But the moment the court appoints an administrator, every person who is operating as a floating charge holder has to step down. It means that if the court hasn't done that appointment, administrative receivership or floating charge administration, floating charge receiverships can exist, at least in theory. In the same vein, if the receiver was appointed by a secure creditor over any of the company's property, he must vacate office the moment the administrator requires him to do so. So these are some things I felt you should know. And you can go through this recording, and then God willing, we'll meet on Wednesday. If you have questions, a few questions, we'll take them. But to all intents and purposes, floating charge receivership will be more or less a theory, existing only in theory, not in practice. I believe it has been subsumed and practically absorbed by the administration procedure, but fixed charge receivership can also exist. Thank you very much. So take care of yourselves, remain blessed, and then go about your day peacefully. God bless you. In Jesus' name, amen.